It is Wednesday, June the 18th. I'm Jamie Fitzpatrick, and this is The Signal. The turmoil of separation and divorce can be very painful, and family court, with its battles over money and children, can make it even worse. But there might be an alternative, a better way for couples to reach a resolution before they go their separate ways. I'm joined in the studio by three guests today. Rona Buchan is a lawyer and mediator with Buchan Law and Dispute Resolution. Janet Tucker, lawyer and mediator with Tucker Law and Jazz Mediation. And Bill English is a retired provincial court judge. Together, they are founders of the Family Dispute Resolution Institute Atlantic. And thank you all for coming in today.
Thank you.
Thank you, Jamie.
Delighted to be here.
We are going to talk about family mediation as a cheaper, maybe healthier way to plan a future for at least some couples when separation and divorce are on the table. It's a big topic. Legal topics can be intimidating for those of us who aren't in the business. So let's start with a basic explanation. Rona, I'll give it to you. What is family mediation? What does it look like when a couple gets into the room to do this?
So family mediation is a facilitated negotiation process, facilitated by a third-party neutral. I'm a lawyer mediator. Janet is a lawyer mediator, but there are mediators in town who are not lawyers, social workers and other backgrounds, mental health professionals. And we are engageable by people who are separating to, as you said, arrive at a separation agreement in a lawyer's case so that you have a plan moving forward. You can move forward with your lives post-separation. What it looks like is I would meet with people individually beforehand just to assess their case, their matter, and determine whether it is appropriate for mediation and apply some screening criteria which would identify whether it's a matter where there might have been any kind of power imbalance or abuse, family violence in the background, or some elements of coercive control. That wouldn't necessarily screen the matter out of mediation, but it would certainly give the mediator needs to know these things and needs to be skilled in designing a process that would address any power imbalances. Once the intake process has been completed, the mediator invites the two people to come to a room together. I always like to start with a joint mediation where they're in the room with me. And we treat it as, I call it a board meeting. It is the business of recognizing that you've spent years and years investing in a family unit. It's a joint family venture. And this is the time you take your investment out of it. So financially, you need to start withdrawing your investments and establishing two separate homes. And from the family point of view, you need to establish your parenting plan and arrangements for support, whether it's just child support and potentially spousal support moving forward. So those are all issues that can be discussed in the room, and the length of time it takes will be determined by the individual matter and where people are in their matter. It's something that can happen at any stage in the proceedings. I receive a lot of clients who are brand new separated. Some are even living in the same house and needing to, as a first step, figure out where they're a separation agreement that'll enable one of them to assume the mortgage on a home and the deed to the home. It can also, however, be an off-ramp from court. So if some people are surprised at how long court can take in a parenting matter, and at any time you can ask a judge or you can take the initiative to step out of the court process or just take time between court appearances to see a mediator and see if you can negotiate a resolution outside of court instead of in the 15 minutes of a case management hearing in front of a judge when you're very limited in your opportunities.
Okay. didn't want to interrupt you. Did
No.
I interrupt you?
No, no. I
Okay.
was trying to address what it will look like. So, yeah, that's essentially what it can look like, and it will hopefully end with a separation agreement when the lawyer does it, or a mediation summary report that you can take to a lawyer and have drafted into a separation agreement.
Bill, I wonder, can you address what it isn't and how it would look different from going to family court and a process that I guess more people might already be familiar with? How is it different from that?
It's very different. They both take place in a room, as Rona said. However, when you're in a courtroom, you're surrounded by strangers. It's a very formal process. There are a lot of documents, mandatory documents that had to be completed and filed. When you're in a mediation, you're in a room with your mediator, who's a trained person, really in the family area, trained in family law, trained in family dynamics. Some judges are specialists when you get into court, and many are not. So what you get in mediation is a private process. It's as private as you want it to be. And that, for many people, is very important. There are all kinds of different families, and they all have different dynamics. But when you're in court, you are, even if the court is closed, you're in a public process. You have to tell your story publicly. You have to swear these documents. They're filed sort of forever. For many people, that's not what they want. My experience is that when people come to a lawyer, they often expect the thing to be dealt with pretty quickly. They really want it to be dealt with quickly because there's a lot of pain and disruption and confusion sometimes. I mean, the law is a foreign language to most people. In separation and divorce, everybody's an amateur. Nobody's prepares for it, and you're finding your way through. But in mediation, you've got the neutral, trained mediator there to guide you through. Judges are great. Court staff, lawyers are great in that process. The problem is they're extremely busy. And everybody there, like in a hospital, is competing for attention. So I think the difference really is you get that attention one-on-one, really, with your mediator. And it can be done so many different ways. Rona can talk about it, and Jana can talk about it. These days, online is an option. But the idea is that you voluntarily agree to try to get to a solution. In court, it's all about orders and mandates and documents that you have to respond to and all that kind of thing. This process tries to humanize it a bit. It's basically people communicating with the help of a neutral person. That's the difference.
And please correct me if I make wrong summations or assumptions from what you tell me, but Janet, is it fair to say that in the courtroom, by its nature, the process is adversarial, whereas in the mediation room, it could potentially be cooperative?
That's exactly right. The courtroom, I mean, lawyers have a mandate where they have to advocate fully for their clients. So it just sets up this scenario where everybody's fighting, trying to win. And you never know what the outcome is going to be. Whereas in mediation, you're looking at finding a solution that you can both live with. It's not trying to make it into winners and losers. It's trying to find some common ground, something that can work for both parties. It might not be what your best case scenario is if you go through the court process, but then you have to go through that court process, which, takes a long time, is costly, and is very stressful, and can do a lot of damage to the family. The end, when you finally reach that verdict from a judge and you leave that court process, there's a lot of damage that can be done to that relationship between the parents, and they're expected to, leave that process and start co-parenting. Whereas mediation, you're discussing that co-parenting and you're actually building on it so that when you leave the mediation, you're set up for a positive co-parenting relationship.
Now, I have a note that I got from my previous conversations with Rona leading up to this show, that you were the first lawyer to add mediation to your practice in this field some years ago?
Yes, there were some lawyers that were offering mediation from just general mediation training. Then I took some family mediation training with Hilary Linton at Riverdale Mediation, who I think we'll be hearing from today.
We will.
It sparked a passion in me that mediation is such a better way to resolve disputes when you're dealing with families. So yes, it motivated me to set up Jazz Mediation, and I've been really excited that we were able to establish the Family Dispute Resolution Institute Atlantic so that we can promote mediation and more people can find out that this is an option, because I think it's such a wonderful opportunity for families to work their way through the issues that arise from separation.
Okay. Seeing as how we're circling around the table, I could put this question to any of you, but I'll try it on Rona. It sounds like a terrific idea in theory. Does it seem to work in practice? Is there a good track record of evidence from this jurisdiction or others to show that it can really be a way forward at the practical ground floor level for families?
I can speak to my experience, but unfortunately we don't have statistics on this here. But yes, absolutely. We're steward of a process that helps people arrive at their own agreements. And I think we always put the onus back on and emphasize that the couple it's a self-directed process. They're in charge of the outcome, right? They're in charge of how long it takes and what issues they want to deal with and how they get to the end result. And some people do it very quickly, maybe 1 or 2 sessions. Other people could go on for a very long time, but still arrive at an agreement. A couple of people drop out during the process if it's not the right time for them. And, we will screen some things out when people are just either not in the right place, or as we spoke about earlier, the power imbalances might be too difficult, or there's not a degree of cooperation with the process. The process relies on having full disclosure of materials and full engagement.
So who is it for, do you think? You did list a couple of things that you sort of screen out, people who you just see aren't suitable or aren't ready for the process. But I guess it's kind of tough to characterize. But what kind of state of mind would a couple be in to be open to mediation and to really be able to make the most of it?
To both agree to participate in the process. I want to, qualify the comment about I won't screen people out if they're not ready. I just want to acknowledge that people are at different emotional stages when they're coming out of a separation. It is a time of extraordinary grief and high emotion. It's the loss of something huge in your life, of a relationship, and that has to be respected. And we try to manage the process, supporting people in arriving the decisions they have to make, just in order to put one foot in front of the other initially, and maybe put some of the bigger decisions off to later, depending on the people's emotional readiness there. But really, we need people's consent. They want to consent to agree to come to mediation and engage with the process.
It was mentioned already that sometimes you can prepare for this with your lawyer and all you get is 15 minutes in the courtroom. Bill, is this part of the appeal of mediation as well, is that you don't have to kind of get in the lineup for the court system? Because we know that all branches of the justice system are under a lot of pressure and often backlogged, right?
That's right. And going to court without a lawyer in any matter is difficult. It's nerve-wracking. It's confusing. In family law, approximately 85% of people who go to court have no lawyer. So if you think about it that way, they're really at a disadvantage. The judge understands the law. The court staff understand the law. The only people who may not understand it in the process are the people most affected by it. And whereas in the mediation field, yes, mediators are not lawyers. They're neutrals. But at the same time, they have that knowledge, and they will try to keep a focus on what the real issues are. So that's one of the main problems, is that you get lost in the legal requirements, even filling out a form and understanding what you have to file. Mediators can explain that in 10 or 15 minutes, and you're not left on your own. So that's one of the big advantages of mediation. Now, mediation can work very well when both parties have lawyers. You asked Rona about experience with mediation. We don't have a private mediation long history in Newfoundland, but there is a public mediation service through Family Justice Services, been around for decades, and they deal with simpler matters. They don't deal with family property. They don't deal with spousal or partner support, but they deal with child support and some custody matters. So I want to acknowledge them because they do good work all over the province. And I know my experience when I was in Labradors, they did tremendous. The people who were there did tremendous work. But they don't cover everything, and they're like all other limited resources. They can only deal with so many cases.
Okay.
They're a free resource, and that needs to be known. And people can self-refer on issues of parenting and child support.
Okay, and what should they be looking up?
They should be looking up Family Justice Services, mediators. They're in all regions of the province.
Okay. You mentioned that we don't have, up to now, a long track record in terms of private mediation for dealing with other aspects of families that are separating. And now we've got on the line Hilary Linton, the founder of Toronto Mediation Services. And I take it, Hilary, you have a bit of a longer track record where you work in Toronto with family mediation. How long have you been doing it?
Thanks for having me on the show. I've been doing this work as a mediator for 25 years. I was a family lawyer for 15 years before that. And you're quite right. We have a longer history of private mediation in particularly Toronto, but many regions of Ontario where there wasn't government-funded public mediation services for a very long time. So that allowed, a flourishing private mediation field to develop.
And in your experience, what works best about mediation? Where is it really, what's the key to good mediation and making sure it comes up with a really successful result for all parties?
It's such a good question. It's really being able to meet the parties where they're at and to be able to provide the thing that they need. Mediation is not, it's the opposite of a cookie cutter. So every mediator needs to, it's a combination of the mediator needs to be trained and skilled to recognize what's needed in every case so that they can really tailor their process and their approach to the needs of the family. And it's also being able to, financially meet the needs of the family. So, I heard reference to publicly funded mediation services, and we do have those across Ontario now. And I know you have them in Newfoundland and Labrador, and it's an invaluable resource because even though mediation is generally going to be a whole lot less expensive than hiring lawyers to litigate in court, it still costs money if you're paying a private mediator, and even for many people that's not going to be doable.
How common is mediation in your jurisdiction and elsewhere in the country? Can you give us a little bit of an overview?
It growing steadily. I mean, mediation has been around in Canada since the late 70s, early 80s. Justice Canada actually really kicked it off by creating an organization called Family Mediation Canada in the early 80s. It's something that as access to justice becomes more complicated and less accessible, more and more people turn to mediation. More and more professionals as well are getting burned out by doing this work. I litigated family cases for many years, and I totally understand how professionals in the legal system can become exasperated, right? Trying to meet the needs of families within a structure that really isn't designed for today's circumstances. So we do a lot of training of lawyers and mental health professionals and social workers who really want to help families and have realized that mediation is probably the best way to do it.
I know that you've worked with Rona Bucket and Janet Tucker, who we have here at the table today. I wonder if Rona or Janet, either of you want to pick up on the points that Hillary's been making here.
Well, Hillary, it's great to have you here, Hillary. Hi.
Hi.
Hillary represents to me like great mentorship and the gold standard in mediation. And I first met her, I found her after I was inspired by Bill to take a degree in dispute resolution. I found Hillary and she said, well, the theory is fine, but you absolutely need the skills. And, a degree isn't going to do it. You need to come to get the training. And she was absolutely right. I couldn't do what I'm doing without what I learned from Hillary. But she reminds us constantly of how important it is to be thorough and accountable and tuned in with our clients and just functioning to the highest ethical standard in our mediations.
Janet, do you recall some of the primary takeaway or some of the primary points you took away from training with Hillary and getting introduced to this practice?
I remember at the beginning, because I was actually offering mediation services prior to taking family mediation training and realizing I felt I was doing such a disservice to my clients. After taking the training, realizing just how different it is. Like you take off that lawyer hat and you're putting on a mediator hat. And so your approach is different. The things you're thinking about are different. You're not trying to apply the law to the people's situation and trying to reach agreement. Instead, you're, exploring what's important to these people. Everybody's so different. So it was, that opening my eyes to just how powerful mediation could be in a family context. And, all the pieces of it, like not forgetting the importance of screening, just identify those power imbalances so that you can adjust the process. You can design the process to make sure that, that there is some balance. And, the motto, I remember the motto I learned from Hillary being, do no harm. And making sure that our involvement as mediators isn't going to actually end up harming the family in any way.
Hillary, does that ring a bell with you? Did they were they good students? Have they learned well?
Well, clearly, very good students. I mean, everything resonates so clearly. One of the things that I learned when I was taking my mediation training was this idea that mediation is a safe place to have difficult conversations. And I love that. I love that way of thinking about it. Right? Mm-hmm. It has to be safe. It's our responsibility as mediators to take reasonable steps to ensure that it's going to be safe in every meaning of that word for people. It has to be legally safe. It has to be emotionally safe. It has to be financially safe, and of course, it has to be physically safe. And so, it's a big job being a mediator. It's a lot of responsibility, but we work with so many people who have spent thousands, sometimes tens of thousands, and sadly, sometimes hundreds of thousands of dollars on legal fees in the court system. And they come to us when they're drained in every way. And we are able to just cut through things and get their case settled. It's truly remarkable what the right process at the right time can do for people.
Before I let you go, I wonder, is the justice system in Toronto, the courts that you work with in Toronto, is the infrastructure and support system there to kind of include mediation, or do we need to get certain building blocks in place within the court system before mediation can take place effectively?
It's a very jurisdiction-specific question. I'm extremely fortunate in Toronto to have a wildly supportive bench, court staff, community, infrastructure. It's all there. We are just ridiculously lucky in Toronto. Not everyone is as fortunate, but it is definitely a cultural piece. I will say, when I started providing court-connected services in Toronto, and this was in around 2011, it was a new thing for a highly litigious family law community. And it took many years for people to understand where we fit in, why we fit in, how we fit in, it takes time for everyone to get their heads around how different this service and this approach is, and how much good it can do.
Well, thanks so much for joining us today. It was great to have you on the show. I appreciate it.
Thank you for having me. Have a good day.
That is Hilary Linton. She's the founder of Toronto Mediation Services. So that last point she made about how you need sort of the culture of your family court system to be accepting of the mediation process. I wonder if, I'm just wondering where we are here in this province with that. And I'll throw that question out there. Maybe, Bill, you could start. I mean, is there a sense in family court in Newfoundland and Labrador that a lot of people aren't familiar with the idea of mediation, or that they have it set in their heads that, no, this is supposed to be about two lawyers getting in the courtroom and fighting it out?
Well, as I said, we're all amateurs in this situation, the parties. And, what we know about courts, we usually know from TV and movies, and it's not like that at all in family court. However, I will say that the court and the court rules for many years now have encouraged mediation. There are settlement conferences that judges do. They've been around a long time. And they also encourage people to resolve their matters by trading off things once they get legal advice. That's always been there. But the problem is that people don't see it through that lens when they come into it. There are all kinds of psychological factors for that, as we talked about. People are very vulnerable, and so they often don't want to think, I'm not going to get everything I'm entitled to. Judges try to turn them away from that, and sometimes lawyers resolve many matters this way. But what we don't have is, and one of the reasons that Rona and Janet and I have founded this new organization, FIDRIA, in Newfoundland, is to promote awareness among everybody, the public and so on. So when this issue becomes an issue in your life, you will think that you have a right to go to court, but you also have a right to mediate. I mean, you have a right to follow either process. And right now, a lot of people just think, I'm nervous about this thing, I'm going to court, I'm going to get what I'm entitled to. Mediation also considers your rights and responsibilities, but it also considers your emotions and your preferences, which are not always the same thing. It's amazing what's important to people, as Janet said as well. You have to meet people where they are, and sometimes you'll find that this is really important, and they'll be quite happy to take that and not emphasize the other thing. So, mediation is a process for doing that quietly, I would think, in most processes, and privately, and quickly. Try to get a settlement conference in family court, and it will take you a year and more, depending on the complexity of matters. So even though the courts promote it, unfortunately, the system primarily leaves people as adversaries, and this is still the situation here. We're working, as so many people are, to change that.
Yeah. As Janet said earlier, it's an inherently adversarial system. That's just how the legal system is designed, with certain parameters. But the fact is that the courts are overburdened at the moment. There's still COVID backlog. There's just everybody's doing the best they can, but it's backed up. And so it's dragging the high and negative emotion of a contentious separation on for a long time is just very damaging to the children. And in 2021, the Divorce Act was revised, and it recognized the benefit to the whole family of introducing family dispute resolution. So there's now actually a duty incumbent upon lawyers, upon parents, upon judges to make best efforts under Section 7 of the Divorce Act to engage with family dispute resolution and try to resolve their mechanism that way. So we're very pleased with these duties, and lawyers know about these duties. But of course, as Janet said earlier, a lawyer's hat is to be the fiercest advocate for their client's interests, and the mediator hat is different. So one of the myths about the mediator's hat is that when you're a lawyer mediator, you advise two people. And I just want to be really clear in terms of our relationship with the court system. We're not advising two people. We are a neutral person guiding people to a resolution, and we want to engage them with lawyers. So the robustness of any agreement I reach with these people, with a couple, is going to depend on them having independent legal advice. And when they get that, and that legal professional is engaging with them in view to resolution, it's a really rewarding process.
So is it fair to say you emphasize the mediator is the neutral party? Mm-hmm. Each person from a couple would come into the mediation. They would have a lawyer or some form of legal advice, presumably just to have someone to reassure them that your rights are being looked after here, that kind of thing?
Yeah, so I want to distinguish it from when you retain a lawyer to go to into litigation. You're looking at a retainer generally of about $5,000. When you're retaining a mediator or just paying a mediator on an hourly basis, you're not having it's not two people investing the $5,000. You're engaging a mediator and then having a lawyer on standby either on an hourly basis or a limited scope retainer. And we're looking for lawyers who FIDRIA can engage to that we know will support the mediation process. People who are interested in being on our roster of lawyers who do independent legal advice on an hourly basis or a limited scope retainer, so that it's not an overwhelming process for people. We are trying to avoid people having like a litigation retainer and a mediator, if at all possible. In the longer cases, like Hillary mentioned, that may be where some people are. It's still a worthwhile investment in a mediator to try and reach that agreement.
With the potential that for people with limited financial resources, you might be able to get through the process a little cheaper than you would have in court. Is it fair to say, Janet?
Oh, definitely. There's still that role of lawyers where, I always encourage my mediation clients to have a consult with a lawyer initially before the first session, because it's good to know what your BATNA is, your best alternative to a negotiated agreement. Because as a mediator, I can't give any advice. It's good that they have advice going into the mediation, so that it gives them a way to evaluate a proposal at the mediation table by knowing how the law would apply to their situation. So going through the mediation process, a typical could take, 3 2-hour sessions, and that's the party sharing that cost. And then there's the cost at the end for them to see lawyers for signing of the agreement, because that's what makes separation agreement strong and binding, is having independent legal advice for signing the agreement. I do require my clients to do that part of it because I want both parties to have an agreement they can rely on at the end of the process.
Okay. But again, that can be quite manageable financially in a all other things being equal in a typical mediation process.
Yes, you could get the whole thing done really for what the cost of one retainer would be for one party for hiring a lawyer to be litigating in court.
So in theory, half the price,
say, give or take.
Okay, well,
could well be half the price.
Very dependent on your individual
Right,
situation. Very, very dependent, as you say. People discuss things they wouldn't normally discuss with a lawyer in a mediation room, right?
Sure. Okay.
But it's an efficient process. What I try to encourage people to recognize is the incredible efficiency of having two people in a room and being able to address an issue together where you're not getting caught up with miscommunication when it's going through through other parties to other parties. And they can get so much done in a 2-hour mediation session that would take a lot of emails between lawyers.
Okay. For another perspective on this now, we're going to speak with Jacinta Gallant. She's a lawyer, a mediator, and a collaborative law trainer. And she's on the line now from Prince Edward Island. Hello.
Hello. Thanks for having me on the show.
Tell us a little bit about your... Sorry, go ahead.
I'm on the highway in New Brunswick on my way to Halifax because so many lawyers want to learn about this. I'm going there to give a 2-day training, so it's wonderful.
Tell us about your background and history with it yourself.
Well, I became a lawyer. I was practicing in British Columbia. I'm from PEI. And mediation was a fairly common approach in British Columbia when I was first becoming a family lawyer. And so I took training and found it was a really good fit. And interestingly, though, even I was even I was still doing some family law litigation, I found that the skills that I was learning as a mediator even translated into that role. So I felt like I was a better communicator. I was better able to understand what clients need, what their concerns are, and really how to be creative in approaching the solutions that they need. So as a younger lawyer, I found that mediation worked really well in all aspects of my work. And then I transitioned into being a full-time collaborative lawyer and mediator, which meant I'm exclusively out of court. You can't make me go back there, even though I was good at it.
So your job now is mediation, and I understand you enjoy spreading the word and spreading the expertise.
Yeah, what's really lucky, I think, because I became a mediator, and then I'm someone, like, I'm a lifelong learner, so I've been always diving deeply into the concepts and the skills. So I became a trainer, an educator, and just timing was right. I've been lucky enough to be teaching literally around the world, sometimes in person, and ever since COVID, a lot of times virtually. It's because so many professionals who work with separating couples really want to help. And even our judges and people who work within our justice system will say it's a rather destructive way to shift a relationship that once started with love and often produced children. And so I feel like in Canada, we're really lucky in that our legislation, our system, and our judges are truly behind helping couples find a way through without the judge having to decide. So you need to know that that's the background here, and what Rona and Janet and the others are trying to do in Newfoundland is really bring that home, where we are used to being in communities with families, and as more and more couples separate raising children together, we benefit communities and society by working in peaceful ways. And so I also want to just say that mediation and a more collaborative approach to separation and divorce even works for people who are really mad, like who are really hurt, who have really felt, deep feelings of betrayal or broken trust, because ultimately with the right support, they can find a way through this that will help their children not suffer. And I think all the research that's been done tells us that. So I really want to support everything that FIDRIA and that our Newfoundland friends are doing to try and bring this home.
You anticipated a question that I was going to ask at some point during this show, which was that people who are, even in the best of times, people who are going to end a relationship, there's usually some sort of feeling of a betrayal or a lack of trust. There's emotional pain. There can be anger, even when they're trying their best to get along. But you still believe, and experience has shown you, that mediation can work if everyone's willing to sit down together?
Oh, listen, it can work even if they're not willing to sit down together. I'll be honest. I mean, there are times where people know they want a negotiated outcome. They want to have control over what the future will hold for them individually as separated adults and for their children. And so that I see more and more couples seeking out something other than court. I'm sure Rona and Janet can attest to the fact that I get clients all the time who know I'm a lawyer and book an appointment and then say, we don't want to get lawyers involved. And when I ask why, it's not just stereotype. It's a fear of losing control. It's a fear of having someone else dictate an outcome that you don't have any input into or ownership of. And there will be cases always where a judge needs to decide. Okay. There's going to be families with levels of distrust or disruption or violence or intimidation who truly need someone else to decide, but that would be a very small percentage. All right. I'm seeing tougher and tougher cases get resolved through mediation and the combination of bringing lawyers together into a collaborative process, and then looking at the other supports available with therapists, child specialists, and parenting coordinators. I'm going to guess Hillary talked about parenting coordination.
No, I don't think so. Didn't come up, did it?
No. Well, there's just so much known now about the process that can help couples reach agreement, and that's like a mediation, a collaborative approach. Could be litigation, I'm going to say, but if we look at the numbers, there's really only going to be 2 or 3% of cases that ever get finally decided by a judge. And so when you front load a separation or divorce process with the right kind of supports, then people are more and more and more likely to resolve it earlier and on terms that really address everybody's needs. It's just how it happens. So parenting coordination has emerged as a process, as a service that a parenting coordinator can provide to parents after they've reached an agreement, so that if they are going to end up with challenges around decision making or following through on specific commitments, a parenting coordinator can be delegated the task of helping them get through it so that they don't go to court.
Okay.
So there's been a lot of work done to try and address the challenges with higher conflict couples. I think we can help them in mediation and particularly in collaborative processes where we can bring in other disciplines. And then after the agreement is reached, after the lawyers are done, after they've got something on paper, to help with changes that need to be addressed or finding ways to remedy anything that needed to be changed without resorting to court. I mean, I had a judge early in my litigation years just from the pulpit say to my client and the other client who had a lawyer, hey, you love your children. I don't even know them. Why would you want me to decide? And so when you take that to heart, most parents with the right support can find a way through because they love their kids.
Well, thanks so much for joining us. That's a really terrific perspective, and we appreciate you taking the call as you're pulled over to the side of the road.
That's all right. I'm on my way to Nova Scotia. I'll be at the border soon. I really love talking Newfoundland, though. Take care over there.
Thanks,
Have a good day. All right.
Bye.
Okay, we also have on the line, I think, a colleague of everyone around the table here, and that's Melissa May, lawyer mediator based in Western Newfoundland. I have that correct, right, Melissa?
Yes, you do.
Where are you on the line with us from today?
I'm in my office in Corner Brook today.
Okay. Now, you work with at least some clients in rural areas, smaller communities, and legal resources there more limited than they would be in larger towns. Is that correct?
Yes, that's right. So I service the western area, which geographically is large and has a lot of small communities, central, and Labrador. I have an office in Labrador as well. So it is far-flung, remote, and there are, at least as compared to St. John's, far fewer lawyers and even fewer who practice family law. And so the access that people who live in those areas have, even if they are interested in hiring a lawyer as opposed to going to mediation, are very limited and can get extremely costly.
And can you say that mediation is a viable option for those people?
Yeah, absolutely. So, one, I'm out here on the West Coast, and I'm not the only one. So there are definitely people around who are local who can assist. But also, it's far easier to connect with a mediator remotely using a video service like Zoom to conduct a mediation than it is to have counsel engaged. So, for example, if you went through sort of the traditional court process, you can have a lawyer from outside of your area, but eventually you're probably going to have to pay them to travel to come to where you are, which can get really expensive. With mediation, we can, within a week or two, be on a Zoom call and conducting your mediation remotely.
I know that in your practice, you were telling me on the phone the other day, you've worked on divorce proceedings with people who run small businesses, and that would include fish harvesters, and the rules are different for them. Can you talk a little bit about that and how mediation can help in that situation?
Sure. So a lot of small business owners, which includes fish harvesters, absolutely. I deal with lots of them. There's just a little bit of a different legal and factual analysis that has to happen to sort out the issues because their incomes are largely in their own hands. And so the legal framework that gets applied to that is different from just an employee who receives a paycheck. And then often there's issues with the businesses themselves in terms of how they're treated between the family. And that can get very complicated very quickly, and then the cost can rise exponentially if those people end up in a high conflict separation. So diverting those people into mediation where someone can sit with them, go through the type of information that's necessary, talk through the issues, and in particular focus on what's important to everybody rather than the technical legal framework that a court would apply to help find a resolution can save the family a lot of time, a lot of expense, and maybe more importantly, the ability to still have a relationship at the end of the day. Because I think, as other people have said here, we all go away. Lawyers, mediators, judges, they don't stay with the family, but the family has to stay with each other, at least in some form, really forever. So for those self-employed people, I've heard stories and I've definitely seen examples where, each spouse is spending maybe six figures on the expense of litigating, where if they had been diverted into a mediation early, they may have been able to get out far more effectively.
Are you able to use an example like that to convince people that maybe mediation is for them? I think a financial incentive surely helps.
Right. So, I can say that I've definitely had people who were self-employed, who had businesses between them, both spouses involved, who had lawyers who diverted them to me, and their final cost, I think, was less than $5,000. And if they had litigated that, they would have both spent tens of thousands easily. And they were able to do it within, a month, and having children involved, so they were able to actually continue to parent that child without the system damaging their ability to do that, even if it wasn't their dispute.
I guess another argument you can use in favor of mediation with some people is, again, if there are children involved, you already mentioned it, there is some way in which the family has to stay together forever, perhaps, or at least until the children are grown and independent. And that is something perhaps people need to stop and give some thought to when they're in the midst of separating.
That's absolutely true. What I say to people, and I say to all my clients, whether they're mediation clients or not, is, when they're in my office for the first time, I say, even if your children are grown, you're going to have graduations, birthdays, grandchildren, their events. Do you want to be able to attend a family event in the future together and have a peaceful event or not? Decide now.
Right.
And that can really shift people's perspective on what's important.
Rona, I see you've been taking notes while Melissa is on the line here. Is there something you have a thought on that you'd like to chime in on what Melissa's been saying?
Well, I love Melissa's example of that. And it's true. We get, the people in the conflict get stuck in emotional places and can't see forward. And it's our duty to help them move forward and try to vision their future and help them determine it. And that example of being grandparents at events or being parents at graduations or weddings, and it being a really happy day for your kids, not kids having to worry about whether mom and dad are talking to each other. So, we really see mediation as in the best interest of the family unit. And another mediator friend of ours says that the divorced kids say that the biggest gift that you can give them is the ability to be in a room together in the future.
That's a really good point. Melissa, anything else you'd like to add before we let you go today?
No, that was what I was covering. Thank you.
Thanks so much for joining us. That is Melissa May. She's in Corner Brook, lawyer and mediator there, and a colleague of yours, right?
Mm-hmm.
Yes. Okay, what's the acronym again?
FIDRIA.
All right, which stands for?
Family Dispute Resolution Institute, Atlantic.
And you're in what today qualifies as the Yellow Pages. People can find you online.
Online, yes. We have a web page. We do.
All right. On the point of the ability to maintain some sort of cordial relationship as a family in going forward, being a really important point that maybe isn't uppermost in people's minds when they're first splitting apart. I think that sometimes family court gets a bit of a bad rap because the stories we mostly hear are the bad ones. If people kind of go through their process of separation and divorce and it goes relatively smoothly, those aren't the stories we remember. If we hear an anecdote at a party about a divorce, it's usually someone who's saying, I tried to be the good person here and I got railroaded, and so on and so forth. Janet, is that sort of a mental block that some people have when they go into your office for the first time, that they immediately think, if I don't go for everything here, I'm going to wind up with nothing because I talked to Bob who lives down the road, et cetera, et cetera?
I think what people hear from other people can affect how they approach the situation. I think with mediation, a lot of times because it's a voluntary process, you have two people that have both agreed to be there. And that's what makes it effective is, there's a lot of times when one party wants to and the other party doesn't. And, sorry, can't help you. But when you have two people that are wanting to try mediation, I think that they want just all those benefits that can assist the family by, there's so many benefits, the cost, the time, to quick resolution, the relationship. There's so many benefits of reaching that, trying to reach an agreement through mediation than going through the court process, which is going to drive people apart.
Right.
I also think people think that it's easier to get a decision from a judge in a court process than it is. They don't realize that a final finding is going to take probably 2 years, during which you're carrying the burden of all the stress, the tension, the negative emotion. And that actually, at every stage of the court process, the court is encouraging you to resolve it. The court's duty is to identify, what can we resolve here? Can you do this by consent? Which is really what we're trying to do in mediation. So we're in a way trying to do the same thing. But as we said earlier, the nature of the adversarial process is such that it becomes a bit of a war.
It can become a bit of a war.
Yeah.
It's the old 60s expression. You can wage war or you can wage peace. Either one is work. Mediation does involve some work. I mean, people have to take part in it.
And you're going to butt heads occasionally.
Yes, that's right. But I mean, the moving towards a resolution, which is really the aim of mediation, is different from going into an adversarial process, fundamentally different. And for those people who are really wanting peace, it's very important. And I make one other point too. Trying to get an urgent result from a court is extremely difficult. These lawyers know, I know. You can start it very quickly, but to try to get it resolved, even something as simple as child support just to get you through the separation period because bills need to be paid, mortgages need to be paid, and so on. Those things are so much easier to do through a mediation process. So even if you had that issue and you wanted to resolve relatively soon, you could go into mediation within, as Melissa said, within a couple of weeks. You could have your meeting, and the only agenda would be to resolve that urgent issue. It might be about children. It might be about support. It might be about even the mortgage. These things drive people crazy. I mean, they worry about them day and night, and we see the effects of it all the time. So mediation gives you that quick result, whereas courts, unfortunately, are not geared to that.
Okay. We're at the point in the show where we have to think about wrapping it up, and I wonder if there are any points we haven't touched on that you guys would really like to drive home. Rona, have we left anything out?
No, I think I'd just like to underscore the accessibility of mediation, that it's an access to justice issue. We've heard that you can get it free through Family Justice Services. You can get it on Zoom. You can get it privately. You can deal with a bundle of issues all at once, or you can deal with one issue. You can deal with it on an hour-by-hour basis or a small retainer, depending on the mediator you go to. So, it's really accessible. You've got control over the time that it takes. You've got control over the outcome, and you can customize your resolution as a family. You can make it. You can be the people who know the children, making the decisions about the children.
Okay. Shall we leave it there?
Thank you.
Thank you.
Thanks, Jamie.
Thank you all for
having
dropping by. That is it for today's show. If you missed any of this conversation, or if you want to recommend it to a friend, our episodes are on the CBC Listen app, also on the YouTube channel at CBC Newfoundland and Labrador. If you have any thoughts on today's topic, you can send an email to thesignal@cbc.ca, or you can leave a voicemail at 709-576 5260. I'm Jamie Fitzpatrick. I'm in this week for Adam Walsh. Thanks so much for listening. I will talk to you again tomorrow when the topic will be vaccinations, COVID, measles, science, misinformation. We'll get into all of it. Hope you can join us.